बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूअर्स, मैं हूं मलिक फ़याज़ अहमद वर्ल्ड एडवोकेट हाई कोर्ट और आप देख रहे हैं मेरा यूट्यूब चैनल। और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके। सेक्शन 423 पावर्स ऑफ एपलेट कोर्ट्स इन डिस्पोजिंग ऑफ अपील। Number 1. The appellate court shall then send for the record of the case, if such record is not already in court, after pursuing such record and hearing the appellate appellant on or his pleader if he appears, and the public prosecutor if the appears, and in case of an appeal under section 411A subsection 2 or section 417, the accused if he appears, the court may, if he considers that there is no sufficient ground for interfering, dismiss the appeal or may. Number 1. A. In an appeal from an order of actal, reverse such order and direct and that further inquiry be made, or that the accused be retired or sent for trial to the court of session or the high court as the case may be, or find him guilty and pass sentence on him according to law. B. In an appeal from a conviction, number 1. Reverse the finding and sentence and acquit or discharge the accused or under him to be retired by a court of competent jurisdiction subordinate to such appellate court or sent for trial, or to alter the finding, maintaining the sentence, or with or without altering the finding, reduce the sentence, or 3. With or without such reduction and reduce the reduction, and with or without altering the finding, alter the nature of the sentence, but subject to the provisions of section 106 subsection 3, not so as to enhance the same. C. In an appeal from any other order, alter or reverse such order. D. Make any amendment or any consequential or incidental order that may be just or proper, omitted by law reforms ordinance 1972, atom 147 CRPC. Section 424 Judgment of subordinate appellate courts. The rules contained in chapter as to the judgment of a criminal court of original jurisdiction shall apply so far as may be practicable to the judgment of any appellate court other than a high court, provided that unless the appellate court otherwise directs the accused shall not be brought up or required to attend or to hear judgment delivered. Section 425 Order by High Court or on appeal to be certified to lower court. Number 1. Whenever a case is decided on appeal by the High Court under this chapter, it shall certify its judgment or order to the court by which the finding, sentence, order appealed against was recorded or passed. If the finding, sentence, or order was recorded or passed by magistrate other than district magistrate, the certificate shall be sent through the district magistrate. Number 2. The court to which the High Court certifies its judgment or order shall thereupon make such orders as are conformable to the judgment or order of the High Court and if necessary, the record shall be amended in accordance accordance therewith. Section 426 Suspension of sentence pending appeal rules release of appellate on bail. Number 1, pending any appeal by a convicted person, the appellate court may, for reasons to be recorded by it in writing, order that the execution of the sentence or ordered appealed against be suspended, and also if he is confinement, that he be released on bail on or on his own bond. 1A. Omitted by Ordinance LIV of 2001 PLD 2002 CANT ST 973. Number 2. The powers conferred by this section on an appellate court may be exercised also by the High Court in the case of any appeal by a convicted person to a court subordinate thereto. 2A. Subject to the provisions of Section 382A, when any person other than a person accused of a non-bailable offence is sentenced to imprisonment by court and an appeal lies from that sentence, the court may, if the convicted person satisfies the court that he attends to present an appeal, order that he be released on bail for a period sufficient in the opinion of the court to enable him to present the appeal and obtain the orders of the appellate court under subsection 1, and the sentence of imprisonment shall so long as he is so released on bail be deemed to be suspended. 2B. Where a high court is satisfied that a convicted person has been granted special leave to appeal to the Supreme Court against any sentence which it has imposed or maintained, it may, if it so think fit, order that pending the appeal the sentence or order appealed against be suspended, and also if said person is in confinement, that he be released on bail. Number 3. When the appellate is ultimately sentenced to imprisonment or imprisonment for life, the time during which he is so released shall be excluded in computing the term for which he is so sentenced. Section 427. Arrest of accused in appeal from ACTL. When an appeal is presented under Section 411A subsection 2 or Section 417, the High Court may issue a warrant directing that the accused be arrested and brought before it or any subordinate court, and the court before which he is brought may committed him to prison pending the disposal of the appeal or admit him to bail. Section 428. Appellate court may take further evidence or direct to be taken. Number 1. In dealing with any appeal under this chapter, the appellate court, if it thinks additional evidence to be necessary, shall record its reasons and may either take such evidence itself or direct it to be taken by a magistrate, or when the appellate court is a high court, by a court of session or a magistrate. Number 2. When the additional evidence is taken by the court of session, or the magistrate it or he shall certify such evidence to the appellate court, and such court shall thereupon proceed to dispose of the appeal. Number 3. Unless the appellate court otherwise directs, the accused or his pleader shall be present when the additional evidence is taken. Number 4. The taking of evidence under this section shall be subject to the provisions of this chapter as if it were in inquiry. Section 429. Procedure where judge of court of appeal are equally divided. When the judge composing the court of appeal are equally divided in opinion, the case with their opinions thereon shall be laid before another judge of the same court, and such judge, after such hearing, if any, as thinks fit, shall deliver his opinion, and the judgment or order shall follow such opinions. Section 430. Finality of orders on appeal. Judgments and orders passed by an appellate court upon appeal shall be final except in the cases provided for in section 417 and this chapter. Section 431. Amendment of appeal. Every appeal under section 411A subsection 2 or section 417 shall finally abate on the death of the accused, and every other appeal under this chapter, except an appeal from a sentence of fine, shall finally abate on the death of the appellate. नेक्स्ट चैप्टर इंशाल्लाह कल शुरू करेंगे 432 एंड 433 तो 35 तक इंशाल्लाह पढ़ेंगे। तो कल तक के लिए मुझे इजाज़त दें। इजाज़त लेने से पहले मैं आप तमाम दोस्तों से और जो नए दोस्त मेरे इस वीडियो पर आए हैं उनसे गुजारिश करता हूं कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि कानून से मुतल्लिक मालूमात हासिल कर सकें आप तमाम दोस्त। या आप लोगों की आगाही के लिए मैंने ये यूट्यूब चैनल बनाया है और आप ही मेरे सब कुछ हैं। अल्लाह ताला आप तमाम दोस्तों को सलामत रखे, सेहत के साथ लंबी ज़िंदगी अता फरमाए। कल तक के लिए मुझे इजाज़त दें। इजाज़त लेने से पहले मैं आप तमाम दोस्तों का शुक्रिया अदा करता हूँ। अल्लाह हाफिज़।